control while the object is still in orbit. Any change in orbital position, any change of function of the space object. And that, of course, has to do also with the entire issue of protecting space from space debris population. And this is important because there you have more and more information that could be of interest in terms of tackling the space debris dilemma by information on decaying, on what measures you are taking in terms of protecting the orbit from a space debris that you might be responsible for. And lastly, the group of governmental experts on transparency and confidence building measures in outer space activities. This is something that has nothing to do with the outer space legal regime or the work of Coopers up till now. But in 2013, an expert group did this study, and it was under the first committee of the General Assembly, which means that transparency and confidence building measures as being security instruments. So this is disarmament, arms control, and security military activities. But the composition of that particular expert group, comprising 15 experts designed by member states of the United Nations, heavily came from the civil community of space activities, which meant that the long-term sustainability of outer space activities, the safety of space operations, the sustainability of operations in orbit have been predominantly covered in that particular report. And if you compare with the resolution up on the top of this list, of this slide, and with the information that are contained in this report, you will see the similarities. So the GGE report covers information on orbital parameters and potential orbital conjunctions, notifications on scheduled maneuvers that may result in risks to the flight safety of other space objects, notifications and monitoring of uncontrolled high-risk re-entry events, and notifications in the case of emergency situations. So you see that there are more and more needs of notification and information exchange procedures generated because we are getting deeper and deeper into the dilemma of space debris proliferation. And in order to safeguard outer space, our orbits around Earth for future generations, there is an increasing awareness of the need to increase the notifications and the general exchange of these parameters that you need really to observe. So Resolution 62/101 helped the registration regime tremendously because it added elements, and we see states using those advices through that resolution in their registration submissions. And now, with the GGE report on transparency and confidence building measures, we're certain that we will see even more. Lastly, just a picture. This is a registration template that we established some years ago, and this is now being increasingly used by states submitting registration data to the United Nations. So the intention is to make registration submissions easier, and it's followed by an instructions, if I say so. So thank you. That was my presentation. Thank you.
Okay, thanks a lot, Niklas. Maybe we'll take one or two questions regarding this issue, but listening to you, suddenly I realized why we did it in Prague. One more reasons why we did that in Prague. I think it's related to Kafka. Because when you were describing these notions of flushing states, and I know that at ITU we have in some of the issue the notion of responsible administrations. I was just wondering what happened when a satellite is built in a country A, used frequencies which has been, as said, if any have been notified by an ITU country B, is launched by a country C, leads to a company which is in country D, and then is controlled by TTNC, which is a territory of country E, and there are just some little hiccup issue that came. Who is responsible? But I won't ask you to respond to that question, but it's true that this notion of responsibility, this notion of words, I would say this morning, we were talking about space stations and that you bring that to our attention, the fact that there's different meaning beyond the same type of words. And this notion of flushing states suddenly has also a meaning which could have existed 30, 40 years ago, which may have changed, and which have a lot of consequence and responsibility. But thanks a lot for this presentation. As I promised, is there any questions at this stage on those international issues? Please.
Just
yes.
to comment on, yes, you really put to the crux of the matter is really I would say, non-harmonized use of terminology, and it's really, space law is really difficult in this regard because the activities themselves have been more complex. We have more actors operating in space now. We have private sector that is really growing market. So it is really important for the entire community, likewise both our community and ITU community, to develop this so that we have a common understanding. But of course, we talk about the launching state. Yes, launching state is not that easy because you have 4 qualifying factors to become a launching state. So there can actually be 4 states that have a launching state capacity for one single launch. And beyond all, the rescue agreement talks about launching authority. Yeah. So I only have one answer. Call in Attila Matas.
Well, thanks a lot. Yes, please.
Just one quick question on monitoring. You set up registration regimes, and you came up with some percentages of what you thought was the amount of objects that had been registered. Where do you get your data? Where do you get your data on the percentage of compliance with your registering? How do you know what percentage of total objects have been registered?
Well, first of all, of course, the data we have, the formal data we have are the registration submissions. So that's one thing. So we capture what has been registered. But then we also go to other sources. It could be websites, organizations that are also, you know, we have contacts, of course, with the authorities that have the tracking capabilities of space objects. So we get information out there that satellites have been launched, but it happens that they are not registered, and we want to provide that information that if an object is in orbit but has not been registered, it's a vital information to this online index to get the full picture. And it has actually helped. In some cases, we really spotted them talk to some states about this. And recently after those states, 2 of them, came back with the registration submissions. Of course, a way after the launching of the object, but nevertheless, they have now been recorded as registered satellites. But this is not a means for actively tracking objects. It's just a means of knowing what has been registered and to get an understanding of what is up there. But it's not an operational tool for actually monitoring at each time the space object is located. So no confusion there. This is not a tracking mechanism.
Yes, please, Jean.
Yes, yes. Thank you very much for your presentation. I have a question because I understand that well, your recommendations more or less depend on the willingness on the launching states. So my question is very simple: what kind of return do you have from the states which actually launch space objects? Well, especially in terms of applicability of these recommendations, because these are recommendations, they are not binding. And how is it translated? How is it? Well, what kind of return do you have from actually in real life?
Yeah. First of all, the requirements under the convention, they are binding. So the convention, registration convention provisions, that's an obligation. But with the resolution 62/101 on enhancing the practice, yes, it's voluntary. We see actually positive trends here, because when this resolution was passed in 2007, it was really a campaign increasing the awareness of this dilemma that there was a downturn in registrations. We needed to get countries to register their objects launched into outer space, and we have seen a positive trend in that regard. When we talk about, particularly when we talk about here on small satellites, I just bring one example because we know that we will have a presentation later by Mr. Kodelka. But if you look at the Bright constellation, for instance, which is a constellation of small satellites, and you will see that the 2 of the partners have registered their satellites. So Austria registered their I think there are 2 nanosatellites, if I'm correctly understood. Yes, they are registered. Poland also registered, but Canada is lagging behind. They have not registered so far, if I'm correctly understood. Yes?
If I may comment, no. Actually, the frequency coordination for the bright frequencies had been done first by Canada, because UTIAS is using for all the spacecraft the same frequency allocation. It is shared. Yeah.
It's in our regime. On the register.
Sorry. Yeah,
yes.
This I don't know.
No,
yeah.
no, but this is the thing. I checked it up. So yes, it's Austria and Poland have done their part. Canada has not registered, but so far, anyway, this is important indication. Austria did it right, because even the small satellites, never mind the size. Maybe this is the only part in life where size does not matter. If I put it that way, but you did it right. So, yeah.
Okay. Thanks a lot, Niklas. Well, in any case, if you have any other questions, there will be the break and Niklas will be there. Please do not hesitate. I will ask now Tanja to come and to talk a little about what exists for those authorization of small satellite on the national space legislation.
Thank you very much, Yvonne, and I would like to congratulate ITU on organizing this event. I think it is really a very good means to build capacity, to create awareness among the small satellite community, and I'm very grateful to have been invited to speak a little bit about the authorization process. So we've just heard from Niklas about the UN treaty regime, and I'm going to talk about how that regime and its obligations are implemented at the national level. And that is, of course, coming a little bit closer to home for the operators here, the operators of small satellites, the universities, the companies, and so on. So I'm trying to bring some clarity in what all this entails. And I've built it up as a series of questions. Why is authorization necessary? Well, we've heard just now that since the outset of space activities, since the beginning of the space age, a set of international treaties has been elaborated by the United Nations Committee on the Peaceful Use of Outer Space. We have a series of treaties and resolutions that govern the activities of states in outer space, and I've put the link there where you can find the texts of all those treaties, and it can be quite enlightening to just read the text of the Outer Space Treaty for your information. And these treaties were based in a time when space activities were state activities, when it was even at the beginning a race between the two superpowers. And that is the global context in which you have to see these treaties. However, that does not mean that they did not already have the foresight that that scene might change, and that is actually what is happening at the moment. You can very well compare that also, for instance, to the aviation framework, where in the beginning aviation was a state activity, and now you take EasyJet like you take the bus. It's really a privatized market. Even air traffic control, airports, everything has been privatized. In space activities, we're going through that sea change at the moment. However, the treaties already in the 1960s and 70s, when they were drafted, foresaw that this might happen and discussed how to do this, how to go about this. And that is the reason why in Article 6 of the Outer Space Treaty, which Niklas also just mentioned, there is this link that has been created between the states, which are under space law, the responsible states as well as the liable states, to create a link between those states and private entities that might start to develop space activities. So there was a need for this link, and that is done in Article 6 of the Outer Space Treaty by saying that any activities by non-governmental entities have to be authorized and continuously supervised by the appropriate state. So this is the key provision that makes the link between the treaty regime of the UN and national regulations that will bind you to these treaty obligations. States have various means of implementing that treaty obligation. You know, the Outer Space Treaty